Hello, everybody. Good afternoon. I'm Rabbi Javier Carapan, and on behalf of our entire congregational family, I'd like to welcome everyone joining us here in person and virtually for our Kansas Supreme Court Justices Forum. Back at the beginning of April, I saw Justice Standridge at a congregational event, and she mentioned that she had been speaking around the state at various gatherings as a way to educate voters about the judicial system. My question was simple: why not at Beth Torah? And she said, no reason, so here we are. It's that simple. We are beyond thrilled to welcome not only one, but two Kansas Supreme Court justices to our community. We could not have gathered here today without the dedicated group of volunteers led by Lainey Decker. If you are here in the sanctuary, we invite you to stand as you hear your names to be recognized. So thanks to Lainey Decker. Thank you. And Donna Gould Cohen. Rick Hellman. There you go, Rick. Thank you. Emily Kirstein. There she is. Hi, Emily. Neil Sater. Thank you, Neil. And David Speisman. I saw him earlier. There he is. We appreciate all your hard work and dedication. Thank you. After the program, we will have a reception with light refreshments where you will have the opportunity to meet the justices. We are grateful to our sponsors who made the many aspects of this evening possible, this afternoon. Special thanks to our staff, our volunteers, our greeters, and our security officers who are keeping us safe. And I saw them and trying to stay cool in a day like today, so we're really appreciating their dedication. We read in the Talmud, Rabbi Eleazar said, "One who causes others to do good is greater than the doer." As it says, "And the work of righteousness, tzedakah, shall be peace, and the effect of righteousness, quietness and confidence forever." I pray that our learning this afternoon will lead us all to work for justice and for peace for everyone in our great nation. Please join me in welcoming Chief Justice Marla Luckert and Justice Melissa Standridge to Congregation Beth Torah.
Good afternoon. Thank you so much for having us today. We really appreciate the opportunity to help explain the Kansas justice system, judicial system of selection of the various judges in various courts in Kansas. It's a very confusing system, and so we hope we can leave you with a better understanding of how all those various pieces fit together and even what those various pieces are. I would like to echo the rabbi and first thank him and then add my thanks to the committee and the group that helped organize today. We appreciate all of those efforts that allowed us to be together. And thank you for not having us outside today. So I would like to start just by telling you a little bit more about ourselves and also a little bit more about our colleagues. We are on the Kansas Supreme Court, which has 7 justices. All 7 justices are native Kansans, and we really do come from all over the state. I personally grew up, and I need to remember not to do that, sorry about that. I personally grew up 20 miles from the Colorado border on I-70, so if you are a person who frequents the Rocky Mountains, you probably know of Goodland, Kansas, which is my hometown, and where I did most of my schooling, although I started school in the big city of Brewster. And you have to pay a little bit more attention as you drive through Brewster to know you're driving through or by Brewster on I-70, but it is also on I-70. I went from that Western Kansas site after graduating from high school there to Topeka, to Washburn University. I am one of those strange, unusual people who at a very early age decided what I wanted to do professionally, and I never changed my mind. And what makes the odds of that even seem to be reduced is the fact that I knew nothing about that profession when I chose it. So I read To Kill a Mockingbird, and I was a child, during the 1970s. I'll give a hint to my age. And so was watching on TV and the news the civil rights movement unfold and seeing what was happening through the power of litigation, frankly, and through those who were trained in the law, who were advocates for social change in that very a time of some unrest and civil fights for civil justice. And with that, not knowing an attorney, not knowing what the day-to-day life of an attorney was, how they were doing the things I was seeing there, and having this vision maybe that everybody was like Atticus Finch, I decided I was going to go to law school. And not having, I'm a first-generation college student, so not really having any clue even about how to go about all of that. In my simple mind, going to a school that had a law school seemed to make a lot of sense. So I headed to Washburn and stayed there and did go to law school, and then stayed in Topeka to practice law. I did a practice that was really fairly varied at the beginning of it, and then became more and more specialized. The firm that I worked with represented a lot of healthcare practitioners. We were counsel to the Kansas Hospital Association, the Kansas Medical Society, the Kansas Dental Association. And so through that, we represented hospitals and doctors and dentists, nurses, all kinds of medical practitioners all across the state. So there was a big chunk of my life that was devoted to actual litigation and the representation of those providers. But there was another aspect of that I found to be completely fascinating, in that we helped them with all of the things they needed to be able to run their practices, their hospitals or institutions. And I became very involved in the burgeoning and new field of bioethics, where the medicine and law came together in the 1980s. And you can imagine some of the issues that we were talking about. For those of you that are close in age to me can maybe remember that. And so I had an absolutely, I like to say, a love affair with the law and what I did, because every day was different and every day was fabulous and fascinating. And I felt like I was really helping people all over the state of Kansas. And then after a while, people came to me and said, "We do not have women on the trial court bench. Would you consider it?" And because I liked what I was doing, I said, "No, I don't think that's for me." But some of them were very persistent, and after several times of rounds of there being openings in Topeka, I decided to throw my name in, and I did become a trial court judge in Topeka and did that for about 12 years. And then from there was decided that I would apply for the Supreme Court, and I became a justice on the Supreme Court in 2003. I am, since December of 2019, have been serving as the Chief Justice of the court, which means only that I have been there the longest. And we'll talk a little bit about how you do all of those things of trial court and Supreme Court in just a minute, but I want to now give Justice Standridge an opportunity to tell you a little bit about her path to the Supreme Court.
Good afternoon. Some people already know me, but I'll go through briefly. I am from Johnson County, kind of from Lawrence and Johnson County back and forth. Went to BBYO, was involved in BBYO here, went to KU undergrad, was involved in Hillel. And then I interviewed on campus with my business degree and went to work for Dillard department stores down in Texas, where I ultimately became a buyer of ladies' ready-to-wear to the tune of spending $25 million a year on clothes. Is kind of how I like to say it. So after doing that for 6 or 7 years, I decided to go to law school. No lawyer in my family. And actually, my mom had gone to college when she was older. Otherwise, you would almost count me as first gen. But decided to go to law school based on an interview with a friend of a friend who was a lawyer. I went to UMKC Law School and graduated. And after I graduated, I became a lawyer to a federal judge. And I did that for 2 years, and then I went to work for a big firm where I did employment litigation. And during the course of that employment litigation, I did a lot of pro bono work in the area of foster care, and really took to that, and decided as a single person that, you know, I wanted to be a foster mom. So when a good friend of mine was appointed to be a federal judge, and I already had the experience of being counsel to a federal judge, I went with that person to the courthouse and left my big firm life and tried out being a foster mom. Since that time, I have adopted 4 kids and from foster care, and during the course of the last 20 years have had informal or formal foster kids to the tune of about 10 others. So, and during that time, after I had adopted 3 of my children as a single parent, you'll like this, I was on J-Date. You know, looking for something to do on date night once a week. And met my husband, Richard Standridge, on J-Date. Now, I wouldn't have told you that if it was, 18 years ago when we met, because back then it was really taboo. Now I think it's more acceptable. But I met my husband on J-Date. We got married. One of the kids that, well, first he adopted my 3 kids, in addition to the 2 kids he already had. We were a blended family of 5. And then one of the birth moms had a baby. And we adopted that child together. So we have 6 children together. My husband was a judge in Missouri. So we lived in separate houses. And he told me about maybe, I don't know how many years in, that I should consider being a judge. And I thought, who would appoint counsel to a judge to be a judge? But that did happen, and I was appointed to the Court of Appeals in 2007 and was on the Court of Appeals for 13 years. And we'll talk a little bit more about the hierarchy of a trial court, where Justice Lukert was the chief judge of a trial court. My husband was on the trial court, and then Court of Appeals, which I did for 13 years. And then in 2000, I was appointed to be on the Kansas Supreme Court. So that's kind of my story.
So we obviously represent one of the 3 branches of government, the judicial branch. We do work closely with the other branches of government on many things. And as Chief Justice, some of my responsibilities pull me in to working with the legislature and the executive branch. As we do try to work together to make policy that helps the entire state. For example, very recently, the judicial system asked the legislature and the executive branch to join with us in creating a mental health summit group to look at how we deal with the issues of mental health, those that have mental or behavioral health issues that become justice involved. And we know on many of these issues that as a judicial branch, we can't do all of the things that need to be done to improve even the judicial system, because much of the judicial system is defined through laws. And even though the executive branch doesn't usually define the judicial system through laws, sometimes their affiliated agents, their executive branch agencies, are very involved with how people come into the justice system. And so we have those situations where we need to work together. But often we also have to remember that we all have our own silos, our own constitutional responsibilities that mean that we stay in our lane and within our silo, and we don't do those things that are left to the silo of the other agencies, or the other two branches of government, I'm sorry, which is really why I at times have to come together with the leaders of those other groups, because I need to have them do the things that are in their silo that impact us. And I know that you know that much of what that is, but the legislature makes the laws. Our job is not to set the policy that goes into those laws, but to interpret the laws that they pass. And so we have internally rules that we follow, where if you read our opinions, which you can find all of our opinions online on our website, you will see that anytime we are dealing with a statute, we always start with these words that say, our job is to interpret the intent of the legislature in the words that they used. We don't add words, we don't ignore words, we use those words. And so that really is our job as the executive branch, through prosecutors, bring cases to us in the criminal realm, or as everyday citizens bring cases to us in what we refer to as civil suits, where one person suing another. And those may involve domestic, they may be probate matters of estates, they can be contract disputes, they can be eminent domain. The government is trying to condemn and take property. There's a wide variety of what those kinds of things can be. And then on the criminal, it can be everything from a traffic fine to first-degree murder. So we have the whole gamut of cases that come before the courts that are based upon the laws adopted by the legislature and brought in the criminal context through prosecutors that serve as agents of the executive branches at either the state level, the county level, or the municipal levels.
The Chief Justice is going to pull back the curtain, that's what it says on our outline, and let you know what we do every day. But before she does, I really want to focus on these three branches of government and talk about how the judicial branch is different. So we know the legislature makes the laws, the executive branch enforces the laws, and the judicial branch interprets the laws. Those in the legislative and executive branches, they make decisions based on the needs and desires of their constituents or their voters, their own beliefs, and or their political party agenda. Judges are completely different than that. Judges have to make decisions based on the law. We can't be influenced by politics, special interest groups, money contributions, media coverage, public opinion, or more importantly, personal beliefs. So there could be times, so you know, that when you read an opinion of ours, which, as they're all on our website, that we could completely disagree personally with the outcome in a case. but we are required by the oath that we take to take the law, apply it to the facts of a situation, and come to a conclusion. And with that, Chief, you want to pull back the curtain?
I will try. Some people I have had express to me the thought that the Kansas Supreme Court reads legislation as it's passed, and if we have a problem with that legislation, then we issue a decision about whether or not it's constitutional or not. But that is not the way it works at all. We never bring our own action, or if we do, we certainly don't adjudicate that because we're doing it as a private citizen. Because just like you or anybody else, we might have a contract dispute or a boundary line dispute with a neighbor or something like that. But we never are bringing a lawsuit to try to impact policy of another branch of government on our own, what happens is that everyday citizens or others bring lawsuits, and they decide which laws they may want us to look at and in what context, and they create their own arguments about them. And we decide those cases based on the arguments they present to us, not on arguments we would have made if we had been the attorneys in the case or the person who brought the case. So those civil cases are brought to the court system in some way by people, your neighbors, some maybe by you, by others who have a grievance or an issue that they need to have resolved in a way that our country has decided to deal with in a dispute a way to resolve the disputes that may arise in a civil society. The other area of the cases are the criminal cases, which prosecutors decide who will be charged. They decide what the charges will be. They decide if there will be a plea agreement. Those things are not left to the judges to do. The judges just hear the cases again as the cases are framed and brought to us by the people who are bringing the lawsuits. Those cases, almost always, all of those will start in the trial court level. And once the trial court has dealt with the case and reached a judgment or a decision in that case, almost all of those cases can then, there's a right to appeal almost everything in the state of Kansas. And almost all of those will first go to a court of appeals, which is an intermediate court of appeals that Justice Standridge sat on. They hear somewhere between 700 and 1,200 cases a year on appeal. There are 14 members of that court. They sit in panels of 3. They are a much more high-volume court than the Kansas Supreme Court is. From that court, if you've brought your lawsuit in the trial court and you lost there, and you appealed it to the Court of Appeals, and unfortunately you lose again in the Court of Appeals, then you have the right to ask the Kansas Supreme Court to review that Court of Appeals decision. It's a discretionary review. We will look at all of those petitions that somebody brings and ask us to look at a Court of Appeals decision. And we only grant a handful, usually less than 10% of the petitions that are filed with us are granted for a hearing in our court. And usually that will be if you have an issue of law where one Court of Appeals panel has decided an issue of law one way, and another group of 3 judges has seen it differently, and they have decided it in a different way. And so we have a conflict of law. And that makes it hard for the trial courts to know what to do because they're supposed to follow the Court of Appeals and the Kansas Supreme Court decisions. So we will almost always take those cases where there's a conflict in the Court of Appeals for us to look at. The other cases we may take, even though we may fully think the Court of Appeals got it right, but it's the kind of an issue that the trial courts and the people of Kansas need to know that that is what the Supreme Court is going to say, because that then becomes more stable, a more dependable precedent for everybody to rely on, because the highest court of the state has interpreted the state law. We will sometimes take cases just to give that level of statement so that people have that to rely on. And other times we do it just because we really think there is a question about whether the Court of Appeals made an error, either in law or in applying the law to the facts of the case. So that is a good body of the case law that we get comes in that way. But we get case law in 3 other ways. One of those is that, I forgot, I can't do that. One of those is that some cases are directly appealed to our court. Those include some of the more serious criminal cases. Death penalty cases come to us directly, as well as first-degree murder and other high-level felonies. We also get cases where a trial court says, this Kansas statute is unconstitutional. That case will come directly to us. And then there are a handful of other cases that the legislature has decided we should get first. Eminent domain is one of those kinds of categories of cases. So there are those types of cases. The next area that we get is when we are asked by a federal court to decide an issue of law about Kansas law. And this kind of gets into what can be a very confusing area about the difference between what federal courts can do and what state courts can do, and who has the final say about what in the law. And it basically comes down to the fact that any court that is applying the United States Constitution or the United States Code, the laws of the Congress adopts, has to follow what the United States Supreme Court says is the law. But if they are applying the Kansas Constitution or a statute of the Kansas legislature, then they have to follow what our court, the Kansas Supreme Court, says is the law about that constitutional provision or that statutory provision. So a case may be making its way through federal court through a variety of ways. One way is if you have a traffic accident with a very bad traffic accident, because the damages have to be pretty high to get into federal court, with a Missouri resident, and you're a Kansas resident, that's known as a diversity case. And instead of having to sue in state court, you can take it to the United States District Court, the trial court, where Justice Standridge clerked. And that judge could say, okay, this insurance provision in Kansas law is ambiguous. I don't know how to apply it. So I want the Kansas Supreme Court to tell me how to apply this insurance provision so I get it right for these people. And so they can certify a question to us and ask us to interpret that. The final way we get cases is that there's a small category of cases that people can actually file with our court. So we're the first court to hear them. Those questions have to be about the law, not about facts or how to apply the facts to the case. If they are, we're going to send that case immediately to a trial court because our court doesn't find facts. The trial court, the judge there who hears witnesses or has a jury that hears witnesses, those are the people who find facts. But, for example, if the governor sees a statute and doesn't know what she is supposed to do under that statute, there's a procedure where she can come to our court and say, please provide me direction about what I am supposed to be doing under this statute. Any government agent can have a clarification of their duties from us. And then there are other types of original actions that can be brought to us, habeas by proceedings by prisoners in some situations, and some other things like that. So we do have some original actions as well. So from our court, if we decide Kansas law, we're done. The litigants are done. But if we have any issue in there that involves the federal Constitution, the United States Constitution, or a United States law, they can appeal and ask the U.S. Supreme Court to review our decision about how we applied the federal law. And so the U.S. Supreme Court would have the final say on those issues, but they couldn't change what we decided on what was a purely state law issue. Is that really confusing? I hope it kind of makes a little bit more sense of how we get stuff.
Okay, a couple things. First, I'm going to bounce off of what the chief said, and then I'm going to go into a question that was asked, and I think the chief is going to go into another question that was asked beforehand. But we are going to try to leave 20 minutes for questions, so I just wanted you to know that up front. So if you have questions, there'll be like a roving mic, and you should feel free to ask questions. What do we do every day? Bouncing off what the Chief Justice said, we spend a lot of time reading and writing. As the Chief said, all the facts are determined at the trial court level, and so, contrary to common belief, someone's saying, I'm going to appeal. You can only appeal if there's a legal issue. Also, if there's insufficient evidence, but that's a legal issue. But you can only appeal legal. So if you feel like, boy, that jury was messed up and, I don't think their opinion was right, you can't do that. It has to be the instructions that were given to the jury, or evidence that came in that shouldn't have come in, or some legal question. And so what do we do every day? Probably 75% of what we do is look at these Court of Appeals opinions on what's called a petition for review. They're asking for us to review, and this is the discretionary review. So in order to do that, for example, we may have 50 of those coming up at a conference. We have to read the Court of Appeals opinion, and then we have to read the petition for review, and then we have an attorney that works with us that writes a summary and kind of gives us a recommendation on whether or not we should take review and actually have oral argument. So how many of those do you think we take on petitions for review? 10%, right? Yeah. So we take 10%. So now that we have this 10%, we have a docket in September, for example. So what do we do to prepare? Well, again, we go back and we read the briefs that were submitted to the Court of Appeals. We read the Court of Appeals opinion, the petition for review, and then we get ready for oral argument. And we have help for attorneys that work with us to get us prepared for that, because in any given week, we may be hearing 20 or 25 cases in 1 week. So it's not like we just have one to focus on. We have to take meticulous notes to be ready to ask questions. We're kind of known as a hot court that asks a lot of questions when the attorneys come in. Now, we have oral argument in our Supreme Court courtroom in Topeka. We do have a live stream, just like this is live streamed. But you are welcome to come. This is open to the public. The live stream, you can just get on our Supreme Court YouTube channel, or actually you go through the website to get on there. But you can watch oral arguments in any case. So, a lot of times the press will pick up, this is a big case that's going to be heard before the Supreme Court. You can watch that. Just go to the website. Okay, so after all that preparing, what we do is we go into a conference with just no staff, just the 7 of us justices, and we hammer it out. take preliminary votes and discuss, and then when we're done, proposed opinion comes out, and then if someone on the court, there's usually a majority that goes with one way. A lot of times it's unanimous, but if there are people that agree with the outcome but not the analysis, they write a separate opinion, and that's called a concurrence. If you disagree with the analysis and the end result, you write what's called a dissent. And so when all that is done, and it goes to our reporter's office, and then those are the opinions that are published. And by then, after it's going through all that, getting ready to be published, we're already working on our next docket. So it's very treadmill-ish, if you know what I mean. Now I'd like to take one of the questions that was asked, submitted beforehand, and that is that, how are judges selected, and how is that different? How are justices on the Supreme Court selected, and how is that different than the United States Supreme Court? The United States Supreme Court and the United States Constitution and the Kansas Constitution dictate how Supreme Court justices are chosen. The U.S. Constitution says that the president will nominate somebody, and then that person is confirmed with the advice and consent of Congress, of the Senate, I'm sorry. So the president picks somebody, and then there's huge background checks, and the Senate Judiciary Committee interviews them, and then it goes to the full Senate, and that's how they're picked. They have what's called lifetime tenure, and the reason for that is so that they can make decisions that are based on the law, even if it's unpopular, and never get voted out. So they're insulated that way, and that's what our forefathers decided would be the best way. In Kansas, our Constitution uses a nominating commission, one lawyer from each congressional district and one layperson, non-lawyer, from each congressional district, and then a chair who's a lawyer. And they interview anybody that wants to apply when a vacancy occurs. So I applied. I had a 102-page application. And then those individuals do reference checks and background, and then you have to interview 9-on-1. And they come up with 3 names, the top 3 names, and submit those to the governor. And then the governor chooses one. So in December of 2020, the governor chose me. And then at the next election cycle after that, general election cycle, which is in November for me, I am up for what's called a yes-no vote. And we refer to that as a retention election. So nobody runs against you, it's just a yes-no vote. Do you vote to retain Justice Melissa Standridge in the office? So that's how Kansas Supreme Court justices are chosen. Now, when you get to trial court judges, okay, like in Johnson County, for example, there's 2 ways that they are selected. Just checking. Oh, I better hurry. There's 2 ways those are selected. One is using the system that we're talking about, okay? It's called the nonpartisan merit selection system. And then the other way is by just a general election, a partisan general election. And what the law provides for in Kansas is that each judicial district gets to decide how they want to select their district court judges, their trial court judges. And so it happens. There are 31 judicial districts in the state of Kansas. 17 of them use the nonpartisan merit selection plan. But the other, help me here, how many would that be? 14. The other 14 use a general partisan election. So for example, Johnson County uses nonpartisan merit selection. Wyandotte County, general election. Okay, Lawrence, Kansas, nonpartisan merit selection. Wichita, Kansas, general election. So across the state, we're almost evenly split, half and half. And with that, I think we're at 3:40. We could, of course, go on. We did have another question, but I'll open it up now for questions if anybody has one.
And I'm going to come around so that everyone can hear the question. Also, since we have many people attending virtually, they can hear as well. And I'm going to take the gentleman right next to me here.
First of all, Your Honors, it's a privilege to have you here. I'm a retired attorney from the Missouri Bar. It's more of a comment than a question. I believe Chief Justice mentioned the importance of reading the words of a statute, and that's your job. I've had a paper published called Words Have Meaning, and that is supported by Chief Justice Roberts and Justice Gorsuch, who in 2017, the Chief Justice had to remind lawyers that there was a difference between the words some and any. And Justice Gorsuch in 2020 in the Civil Rights Act used a dictionary and looked up the words sex and individual to support the Civil Rights Act of 1964. So, and both justices reminded us that we people here have a right to depend upon the words that our legislative branch writes, and that the job of the justice of the judicial branch was not to change those words, but tell us that that's the wording, that's the end of the game. And I just wanted to bring that, and thank you very much for mentioning that.
Thank you. No, it's so true. And so what I try to tell people is often if you don't like our decision, what you need to do is talk to your legislator, because that means they need to change the statute if you can persuade them to do so.
Okay, we have another question here.
Yes, thank you very much for being here this afternoon. Brown versus Board of Education, obviously probably the most famous case to come out of Kansas. And I was wondering if you could trace, it ended up at the United States Supreme Court, but my guess is it didn't start there. Could you explain what different courts it went through and the reasons they were able to appeal to the higher courts?
The Browns brought their suit, and there were several suits across the country that were consolidated into the case that we all know of as Brown. And it happens that alphabetically, Brown was the B, led the charge just because of the alphabet. So we know it is Brown versus Board of Education. But Brown was brought in U.S. District Court in Topeka and was tried there. If you go to the downtown post office in Topeka, Kansas, at the time of Brown versus Board of Education's trial, it was actually both a post office and a courthouse. The second floor was the courthouse, and you can still go up into the courtroom and see where the trial of Brown versus Board of Education occurred. So a Topeka located judge made that decision. It was started with mostly attorneys from Topeka. The interesting thing for me as a young attorney and as I've aged has been that if you look at pictures of the Topeka bar in the time before Brown and at Brown, our bar was very diverse. And it's gotten less and less so over time, as I think is true, unfortunately, of other professions sometimes as well. But anyway, we did have a very active group there that started it. They then affiliated with attorneys, including Thurgood Marshall and others who were able to bring the case. It went from the Topeka courthouse to the 10th Circuit, which sits in Denver, Colorado, and from Denver was then appealed to the United States Supreme Court. Yes.
How often are you up for retention? And since you're on the ballot, can people put campaign signs out for you to be retained?
Did you hear? I had trouble hearing all
He said, since we're on the ballot, can we put campaign signs out? We do not campaign in the way of a typical campaign. There are groups that do campaign or do advocate for or against the retention of justices.
and those groups often do have yard signs. So there is information. There are ways to get yard signs, but we typically do not run our own campaigns or run our, so you won't find me handing out yard signs that say, retain me, So, and I cannot, under our code of ethics, I cannot ask you to retain one of my colleagues. I can't endorse another colleague, so we're somewhat limited. On the Supreme Court, we're up every 6 years. If those of you that live in Johnson County or another merit selection county, your district court judges are up every 4 years. When I first became a trial court judge in the 1990s, there rarely were any pushes for or against retaining judges. That's changed as that has changed over in the ensuing decades. The last 2 elections for us, there were factions on both sides doing television ads, social media ads, and other things. And we'll see what develops with this but between now and November. There will be, the Johnson County Bar is doing a evaluation of their judges as well as the Court of Appeals and the Supreme Court judges. So there are bar associations that do, and they're not the only ones, there will be other bar associations that do evaluations that would help you as non-attorneys know what the attorneys think. We consider this a little bit like if you were going to go find a specialist to do your open heart surgery, would you ask a doctor or would you ask your yard, guy from Shingles that's putting fertilizer on your yard? Usually you would go to the professional. And so this is a way for you to go to the professional and get an idea of whether I'm doing a terrible job or decent job or not. You can also go to the website. As we've mentioned, all of our decisions are there. There are also archived videos of all of our oral arguments. So if you hear a case talked about, I urge you to read the decision and also to watch the oral argument because I think it helps provide insight and understanding about what it is.
We are lucky here because unlike other, especially, out in Western Kansas too, that the Johnson County Bar, they actually use a software program, they hire a company, and they talk to jurors, litigants, lawyers, other judges, and they do a survey, and then they post that survey. It should be up in October, so you just need to go to the Johnson County Bar Association. Johnson County, a bar is like a lawyer association. And they also included us in that and the Court of Appeals, in addition to the 25 or 27 judges in Johnson County.
There was a question down here before.
I'm headed there. I'll take this one and then we'll go over there.
Oh, poor thing.
Hi. I realize that you don't choose the cases that you hear, but recently we had Amendment 2, and the wording on it I thought was awful, and the explanation was possibly worse. But I'd like to hear what you think of the wording on the amendment. Thank you.
That is an example of what gives us job security. The legislature chose the wording. The legislature, that was part of the statute they adopted. And so your legislators voted to use that wording on the ballot and to ask the question in that way. And they often give us things that cause us to all go like this for hours and hours and hours sometimes trying to figure it out. So that is why we do have a role. If it was clear, if it's totally clear and everybody understands, everybody agrees on the meeting, they don't need to come to court for it. It's where that wording is hard to figure out that it ends up in front of us often. So, but yes, it could be a textbook example, I think. So.
I think the two of you have done a great job of talking about how the Supreme Court operates and how Court of Appeals operate in terms of matters that come before them and how they get there. My question relates to the recent issue that seems to be the point that your elections this time around are particularly popular. Generally speaking, you guys get voted in almost automatically. This time around, it sounds like there might be some question as to whether, in fact, you will automatically be elected. I think it'll probably still happen that way. But I think it would be helpful if you would explain the logic that the majority went through in making the decision that, in fact, the Constitution required the abortion issue to be dealt with as you chose to deal with it.
We are limited in what we can say because that is still an active case. After we decided the Hodes decision, which is the abortion decision that led to the constitutional amendment, we adopted the test of what we thought, a test for the trial court to apply. The trial court had applied what the U.S. Supreme Court's decision had been under Roe v. Wade, and we recognized that the language in the U.S. Constitution is different than the language in the Kansas Constitution. And so we were focused on the Kansas Constitution and developed that test. So we remanded it to the trial court level and said, apply this test that we have now laid out in our decision. That went back to the trial court. There was additional evidence presented and hearings there. And then that has been appealed back to our court. Briefing is underway right now on that. And so our canons don't allow us to speak about cases that are pending or impending that might indicate how we would decide. This is a lot like when you go, how many of you served on a jury? A few. Did you have the judge who kept saying, do not make up your mind, keep an open mind until you have heard all of the evidence? This is somewhat debated, but social scientists and many believe that if you enunciate your position early, then you feel bound to defend your position, and you lose some of that impartiality. And so our canons have chosen to tell judges, do not articulate a position until the case is all before you and you're ready to decide. So that's what we do, and I know it's sometimes frustrating to not have us answer the question, but we are limited in being able to do so. And again, this is part of what sets us aside from our politicians. We are not going to tell you that we're going to take this political position or that political position, because that's not our job. Our job is to look at the law, the facts, and then apply them.
So you're going to see this issue again?
We will. The Hodes, the Hodes case, that argument will possibly be heard by us if the parties, as I said, are briefing, and some of that depends on when they get their briefs in, but will be heard by us in one of our next upcoming dockets. So it's coming fairly quickly. So, yes. And so, yes.
I'm getting my steps in, headed that way.
Hi, thank you so much for being here. You mentioned the 2019 Hodes and Nassar versus Schmidt decision. My question is, and I think that was a per curiam opinion, but are there any of the justices who signed off on that opinion, are they up for retention in November? And do you see that? If so, I see you nodding. Do you see that as maybe the value them both, like maybe trying to influence getting those judges off of the court?
Yes, we have had some of the justices who were on that have retired, but 3 of us are on the ballot this time. And in addition, Hodes went through the Court of Appeals, so judges, the Court of Appeals actually split evenly on Hodes. And so we do have a justice who was on the Court of Appeals and heard the Hodes decision at that level as well. So 4 of the 6 of us who are on the ballot have voted in Hodes, and our vote is public. Of the 2 who remain, one of those people, when that person was moving through the nomination process, there was some information out in the press then, where they were saying this person's spouse had contributed to the governor, and that then meant they had to know how this person would vote if they had been on the case. And so there will likely, that person will get thrown into that same argument again, would be my guess, which is interesting from many aspects, in that, as we have both tried to emphasize, what we do on the bench is not necessarily what our personal beliefs are. So, you know, trying to guess what our personal belief is by what a spouse has done in an, you know, or which we won't even get into those issues, but that is not a good litmus test for how a person will decide a case.
So overall, as the flyer said, though, 6 of the 7 Supreme Court justices are up for retention vote in November.
This is frankly a little bit of a flaw in our constitutional method. Other states have developed ways to stagger this so that no court can basically have so many justices on the ballot at one time, but it's just a happenstance of when retirement dates hit, you're on the ballot a year after you come on the court to start, and then every 6 years after. So it just happens to be the way this worked out.
Okay, we have one more question here, and I will remind everyone that there will be time for questions in the reception after this. The justices have graciously agreed to stay and take any questions.
Thank you again for being here. It's been very interesting. I'm not familiar with what they're talking about, the Hodes, so I would like you to explain a little bit about that. But I also wanted to ask you, are you allowed to abstain from a decision?
Not in the sense we can't abstain from a decision that we are called on to decide. In terms of, I just can't say, you know, this is just too hard, I can't do it. On the other hand, if I have a personal interest of some sort, or a spouse that would have a personal interest, like a business interest, you know, I'll just give an example. If you feed your science diet to your pets, my husband was the general counsel for the Hills Pet Nutrition that manufactures Science Diet. I think twice in the time I've been on the court, they've had litigation that's gone through our court, and because he is paid, part of my family income comes from Hills Pet Nutrition. When those cases come through, I'm not going to sit on those cases. So that's just an example of, yes, there are times you do not sit on the case as a justice. But in the general rule, we have to, and in fact, it's an ethical slight of ours if we just make up a reason just so we can avoid a case. We can't do that. What we're talking about is a decision, 2019 decision of the Kansas Supreme Court in Hodes versus Nausher, which you will find on the website. And it is where a majority of the Kansas Supreme Court recognized that the Kansas Constitution recognizes a right to personal autonomy in making medical decisions about our own bodies and about whether to have a family or to raise children, all of those things that make up the kinds of things about bodily autonomy. And because of that, recognized right for a woman to decide under whether to carry a child. And we recognize there are limitations on that, and that the state can impose limitations on that if they meet a test that's known as the strict scrutiny test. So if they can come into court and show under this strict scrutiny test the reason for the state regulation, then the state can regulate the circumstances. So that was the Hodes decision in a nutshell, and it's one that you can read for yourself or you can hear other things about. So.
Here comes Aviva. Oh, you want to come up here?
On behalf of Congregation Beth Torah, thank you very, very, very much. It was such an honor to have you here with all of us in person and also dozens of connections online. So thank you for being here. Thank you for taking your Sunday afternoon. And we're so honored to have one of our own also. So thank you, thank you. Another round of applause. In just a moment, all are welcome to join us in the Ulam, which is our social hall, for a reception with the justices. And also in the Ulam, we have the League of Women Voters of Johnson County, who have voter information. So please make sure to check out their table. Again, thank you all. It has been such an honor, and we'll see you in the Ulam.